All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Welcome to the North Carolina Court of Appeals. We have one case on that's a little unique for us. Normally arguments are 30 minutes, but we're going to focus on one issue. So this will be 20 minutes, Mr. McFarland. The case that's on the docket for this afternoon is State versus Thomas, and it's Court of Appeals 24-940. We have Mr. Bowman as our marshal here with us today, in for Mr. Salou, and Roderick McFarland is our clerk. To my right is Judge Jefferson Griffin, and to my left is Tom Murray, and together we make up your panel. Is the appellant ready for arguments? You may proceed.
May it please the court, I'm Rudy Ashton from New Bern. I represent Carlton Thomas in this case. Briefly, he was convicted of felony, fleeing to elude arrests, also trafficking in fentanyl by possession and transportation, and trafficking in methamphetamine by possession and transportation. All of this resulting out of a high-speed chase on I-85 in Gaston County back in January of 2023. His consecutive sentences totaled 310 to 402 months. For the issue you wanted argued, this has to do with the drug amounts. Drugs were found in the roadway, I-85, in the ditch by the area where the car came to a rest, and then in the car itself. Several bags were collected. They were submitted to the lab, and the largest bag was analyzed. It was 36.37 grams of a mixture, and the mixture contained some fentanyl, some methamphetamine, and some ANPP precursor. And that's sort of where the issue arises here. You asked us to be prepared to argue whether there was sufficient evidence to support separate convictions for trafficking in at least 28 grams of methamphetamine and trafficking in at least 28 grams of fentanyl. My short answer is that independently, taken one at a time, yes. However, as a lawyer answer, when they're both, no. And that's the crux of the defense attorney's defense. His motion to dismiss his objections to some of the jury instructions, allowing one mixture with two drugs in it to result in two separate convictions and two separate consecutive sentences. And so that's the basis of this. In support of this, I think I had not really thought about it initially, but there is some ambiguity in the legislative intent, I would submit, when there are several drugs involved in the one mixture language. The Hall case has been cited by both of us. I am familiar with the Hall case, but basically it didn't involve trafficking, and it was two separate drugs in two pills, and the lady received not consecutive sentences, but a 45-day jail sentence and then 18 months probation. The important thing about Hall that distinguishes it here is it specifically said that the amount of drugs in issue, the quantity, was irrelevant. And that's why I did not prevail on my representation of Ms. Hall several years ago, because since it was not a mixture, it was just a quantity, two pills. Didn't make a lot of sense to me then, but now that we've come a long ways, it does, and it's definitely distinguishable by this. unfortunately, there is no case. This is an important issue that addresses several drugs in one mixture when separate convictions are brought and then separate sentences. The Ellison case was also cited by both of us, but again, it's not controlling. It's a trafficking case, but it only involved one drug, an opium. So from that standpoint, it's not controlling. Judge Hudson did have what I thought was an interesting concurring opinion that it's only supposed to target large-scale drug dealers. But again, this issue did not arise there when you actually have a mixture containing several different drugs.
Is it your contention that by being convicted for two different drugs, are you considering that a double counting?
When they're in one mixture, I think if they'd analyzed two bags, and one had one and one had the other, they could certainly do consecutive sentences. And you can do consecutive sentences, I believe, for trafficking by either possessing or manufacturing or transporting. But to have two separate drugs where the weight is the issue, the quantity has to be 28 grams or more for both the meth and the fentanyl. Now, they don't have to weigh that much, but the mixture has to. And we don't know really what's in the mixture. I think the chemist in this case testified.
So would they
not have a figure or an amount for the fentanyl or the meth.
under your reasoning, would it, if there was another bag that was weighed that had, an equal amount, but they both got you over 28 grams of mixture, would that be sufficient to sustain those multiple convictions?
If they analyzed two bags
Yeah.
and found meth in one and fentanyl,
There's even the same mixture in both bags. Just the weight got you to where you needed to be for the state.
I believe they could do it that way because, yes, I would think so, because they would be separated and you sort of know that they each had 28 grams or more in the bag and in the mixture and possibly. Another problem we have with this is, let's say that there was cocaine involved. I think one of the officers or troopers said he thought it was cocaine when it was first saw it, but it wasn't. It may have been in one of the other bags. And if they had analyzed another bag and found cocaine, I certainly believe they could have charged Mr. Thomas with that as well. But to charge him based on this one bag with both the methamphetamine and the fentanyl, it's all right to charge him, I guess, but by the same token, to convict them and sentence them for both consecutively, we would submit it. It's not the intent of the legislature in this particular case.
So you had mentioned earlier an ambiguity in the statute. Is it your contention that the statute is ambiguous as to whether a single bag weighing greater than 28 grams containing a mixture of both methamphetamine and fentanyl is a single charge? Is that where the ambiguity lies?
Yeah, the ambiguity is whether it's a single charge or it can be two or three, four charges in one. And I believe there is some ambiguity on that. Of course, the burden of proof is on the state. They can always get the analysts to analyze more drugs. I know they're sort of understaffed and overworked, and they've been behind. I think they're catching up. But I think the protocol now is to just analyze one, especially if it goes to what they call the highest level. And in this case, I think the entire amount of drugs Officer Medlin, I believe, weighed them before he submitted them. It was like maybe 75 grams, something like that. Also, as I argued, yeah, we consider the legislature did not intend for this. There's no way to really know. That's
I
why,
was gonna say, how are you, I mean, you're making that argument, but can you point to anything to show that wasn't their intent?
sir,
Can you point to anything to say that wasn't the General Assembly's intent, that the statute be read that way?
no, I can't point to anything say it wasn't their intent, but we're not sure what their intent is as we get through this. And also,
I guess if we go that, then, you know, what does the plain language of the statute say?
well, the
you-
plain
you can't-
language is a mixture containing a certain amount. But then we get down to not technically double jeopardy, but they're sort of associated with the merger doctrine. And basically, in the merger doctrine, you can't have overlapping offenses for a single transaction. We see that in felony murder. If someone's convicted of felony murder and the underlying felony was maybe robbery or whatever, unless it's a premeditation deliberation also, the felony murder, the underlying felony is judgments arrested in that. And we did provide a memorandum of additional authority, basically going to ambiguity and rule of lenity, and that matters. The Conley case involved simultaneous purchase of multiple firearms and educational property. That's one of the more recent cases. And the defendant's convicted of several offenses, and this court basically, upheld by the Supreme Court, said, well, you're on the property once, you had 2 guns, but you know, that's one charge. Same with felony possession of firearm. I believe we cited the Garris case, very similar to the Fourth Circuit opinion in Dunford. It used to be, you know, find five guns in your car, you can charge them 5 times. Well, now if it's one simultaneous act, you shouldn't. And then the Smith case has to do with obscene magazines. One transaction, bought several magazines, still only be 1 sentence. And here, the elements for felony fleeing to elude arrest, to make it a felony, it has to have 2 of 3 other issues, other elements. Driving license revoke, reckless driving, or speeding in excess of 15 miles over the speed limit. Of course, the judge gave all the felony elude charge plus all 3, and the jury found him guilty of all 3, so obviously it's a felony, but then he arrested judgment on the other 3 because they were elements. And that's the thrust of our argument, basically.
Is your argument that possession of trafficking weight methamphetamine, that the possession of fentanyl is also an element of possession of methamphetamine?
The argument is the weight becomes an element. I believe several cases say that. I think I cited the King case and the Coleman, that the weight is now an element to get the case from regular drug case under Chapter 90 up to trafficking.
All the elements of possession for each respective drug have to be met, and then the weight is what pushes it up to trafficking level and changes the sentencing structure, as you know.
Yeah, it certainly.
Why do you think the legislature used the word controlled substance or any mixture containing substance? Why do you think they used the word mixture?
I believe they probably used it, my understanding, to you weigh the stuff and it exceeds 28 grams, which is an ounce, 28 grams or more. It may or may not be exactly that. It could be 5 grams, 10 grams, 29 grams, or whatever. And it could be about anywhere. And when people cut it in mixture, the intent, I believe, was to stop the dealers from selling over an ounce of whatever it was.
I think you're onto something there. In the federal system, they have the theoretical yield calculation that they do, so you know what amount. We don't have that in our state statute.
But I believe the intent of the legislature, was to get at the drug dealers selling large quantities of drugs, But if you use a mixture, then if it's a lot that only has a little in it, it's been cut a lot, it's still, the intent was there. And it ought to, makes sense to me. I think it was, that's reasonable. The problem is when you start mixing them together and has separate, what do? Do you do an election? I'm not sure if or you go all the way through the jury like a civil case and elect whether you want punitive damage or treble damages. I'm not sure exactly where this goes, but I would submit that the lesser of the two that's consecutive judgment ought to be arrested rather than have two separate judgments.
So on the record evidence, were there more bags than the one that was tested in this case?
Yes, there were several bags, or 5 or 6 bags. The Trooper Gagnon was out on I-85 scooping some up in a glove and a bag, which he gave to the Gastonia police officer who met him. And then they found something with a brownish substance in the Yeti. There was a Yeti bottle on the ground outside the car, outside the driver's door. The top was found on the floor. That had something which wasn't analyzed, and then some more in the car that was not analyzed, and then the bag was analyzed. On the floorboard was the largest one, with the 35.36.
That was the 5-minute light that came on. You didn't reserve any time for rebuttal, but you can still do that if you want to.
Yeah, I'll reserve a few minutes for rebuttal.
Good. Good. Thank you, sir.
Thank you.
State.
Good afternoon. May it please the court. My name is Brooke Schmidley with NCDOJ. The state requests that the court find that there was no error in this case and affirm the convictions and the sentence, finding that this evidence was sufficient to sustain convictions for trafficking fentanyl and methamphetamine. The fact of the matter in this case is that the defendant does not contest that the state met its burden to prove each element of each of these offenses. In fact, he says so in his brief. Secondly, we are dealing with the Controlled Substances Act and 2 different provisions, 2 different statutory provisions that prevent trafficking. We are dealing with 9095H4, the opioid trafficking provision, and 9095H3B, the methamphetamine trafficking provision. And the intent to get to the court's question of the legislature has been analyzed in many cases, including the Ellison case, where the Supreme Court said the intent of the General Assembly was to deter trafficking of drugs. That is why the sentences are often harsh. And in this case, the language that you specifically asked about criminalizes trafficking, not only the substance, but any mixture containing that substance. And that language exists in the opioid trafficking in 9095H4 and also in methamphetamine. In addition to that, we have the State v. Hall case, which I would urge the court to look at more broadly than the way that the defendant appellant discusses it. The issue in that case was whether a defendant could be convicted and sentenced for the possession of 2 different drugs, ecstasy and ketamine, when those are in a mixture in a single pill. So it was not analyzed by charging 2 separate pills. The question that this court answered 15 years ago was, can he be separately convicted and sentenced for possession when they are in a single pill? And the answer of this court was yes. First, they looked at a motion to dismiss, the same as we have in this case. And when they evaluated that, they said the state had evidence of each of the elements of this. This is not about the state not proving the elements of the case. What the court said the defendant was really objecting to was being sentenced for 2 drugs that are contained in 1 pill. And so they did the analysis to determine, would this violate double jeopardy? And they used the Blockberger test that is well known and specifically relates to when an act violates 2 different statutory provisions. The test is whether each provision requires proof of a fact that the other does not. And this court also described it in the Cameron case. The test is not whether the defendant has been tried for the same act, but whether he's been put in jeopardy for the same offense. So in this case, the state had to prove the existence of the fentanyl, and the state had to prove the existence of methamphetamine. The state did, in fact, have to prove an additional fact. It would not have been sufficient had we only had evidence of methamphetamine to sustain the convictions for fentanyl.
And so the element of over 28 grams of a mixture containing methamphetamine, do you consider a mixture containing two different drugs, like in this case, is that a double counting issue, where you're counting 28 grams twice? Is that a double counting? Is this drug being counted twice? That's the question I'm asking.
The state would contend that it's not a double counting issue. The mixture can be any mixture. It's any mixture that contains that drug. And so, whatever is in there with the drug can be sugar, it can be a filler, it can be non-criminal, any mixture that contains that drug. The question that we're getting at is, he got sentenced because this mixture contained methamphetamine and it also contained fentanyl. But we are dealing with two different statutory provisions, right, of the Controlled Substances Act.
But it's the same weight. And that's Mr. Ashton's argument, if I understand it, is that you have possession established.
Yes,
I think
sir.
he concedes that. The state established possession of methamphetamine. Then we move to how much? More than 28 grams, trafficking.
Well, that's,
Then we have the same elements established for fentanyl. How much? More than 28 grams, but it's the same 28 grams because they only tested and weighed one sample of the multiple samples they had. That's his argument. You can't count the same 28 ounces twice for the weight. It's only 128 ounces any way you split it. And his argument is that you're piling on by saying, well, there's a little bit of this and a little bit of that. It could be 0.01 ounces of methamphetamine and everything else is fentanyl. He would be guilty of trafficking. That's his argument. So how's he wrong?
because there are two different statutory provisions. Let me back up even. The analysis in Cameron shows that that is an incorrect argument, that we are not looking at just whether the defendant engaged in the same transaction or he's being punished for the same act. That's what the language of the holding says. We are looking at, is he being punished for the same offense? These are two different offenses.
Correct, but the weight on both is the same.
Yes, sir.
And the weight, for statutory purposes, the weight on both is the same. But also, there's only one weight that we're considering here. It's a mixture, and it's in my view, as I understand it, it's different than, certainly there are two separate elements, but there's an additional element when we're dealing with trafficking, i.e. the weight.
Yes, sir.
But
So
we only have one weight.
And how can a 36-gram bag be used to convict somebody for over 28 grams of methamphetamine and over 28 grams of fentanyl under the statutory construction? I think that's the essential ambiguity question that we're asking.
So I can answer that two ways. The first is that the statute sets out that if a defendant traffics in 28 grams or more of fentanyl or any mixture containing fentanyl, then that violates the trafficking in 9095H4. If he traffics 28 grams or more of methamphetamine or any mixture containing methamphetamine, then he violates 9095H3B. He violated both of those in this. When you look at the intent of the General Assembly, and I would actually say that this is not, it's not ambiguous. The General
That's my question. Is what? So your friend on the other side says, any mixture, that's somewhat ambiguous. What is your argument? What's the government state's argument that's not an ambiguous phrase.
Yes, sir. So it's twofold. First, we're dealing with two different statutory provisions. The cases he cited to you in Conley and Garris, we're dealing with one statutory provision, the possession of firearm by felon, and whether the description of any firearm meant one firearm or two or multiple firearms. We are dealing with different statutory provisions, one of which is trafficking fentanyl, one of which is trafficking methamphetamine. And so the General Assembly was very clear. If you traffic in any mixture that contains fentanyl, then this is, at various weights, this is your sentence, right? The General Assembly was very clear, and same for methamphetamine. And again, when we're looking at the question that's before us, this was addressed in the State v. Hall case. We had one pill that contained two drugs, and the question was, can the defendant be convicted and sentenced for both of those drugs when they're in the same pill? And the court said, yes, they can. And
There's
they said,
no weight.
Yeah,
There's
I
no weight
think-
component. to
Yeah,
that.
I think your friend would concede that is accurate and would not contest that. I think it's a weight argument, yeah.
I think he concedes you got him on the possession
yes,
of
sir.
fentanyl and methamphetamine. He's his position is you can't use the same weight twice when you only have one weight.
Well, before they talked about the amount in State v. Hall, before the court did, they set out that foundational holding in Blockberger and Cameron, which is, does the state have to prove an additional fact in order to reach the conviction? And that's the seminal difference. That is what the law is. We had to prove that it was a different drug. Interpreting it the way the state is asking you to, and the way that we believe that Hall supports, gives prosecutors tools to deal with problems of one drug being laced with another. And that's why the state contends that these are different acts. Methamphetamine is a profoundly dangerous drug. Methamphetamine that's been laced with fentanyl is a profoundly deadly drug. And by setting these out in different parts of the statute as trafficking in fentanyl or any mixture that contains fentanyl, trafficking in methamphetamine, or any mixture that contains methamphetamine, that allows us to get at the issue of lacing drugs and allows judges to hear all of the evidence and make a decision as to what is the right sentence in a particular case. But the issue goes back to, is it really unfair? It's harsh. It is harsh. But the General Assembly meant for it to be harsh to deter drug traffickers, exactly what we have in this case. The issue is, are we punishing him for the same act, or are we punishing him for the same offense? Because the question is, and the rule is, we cannot punish him for the same offense. But when that bag contained not only methamphetamine, but also fentanyl, we were not punishing him for the same offense. We were punishing him for a much more deadly offense, with the lacing of one drug with another, and trafficking in that manner. Furthermore, as it relates to the sentence in this case, the court, when he was convicted by possession and transportation, trafficking by possession and transportation of fentanyl, Class C, and that was consolidated. And then he was convicted by trafficking by possession and transportation of methamphetamine, and that was consolidated. And it was those two sentences that ran consecutively. And so he could have been sentenced to consecutive sentences on the Class C for the possession of fentanyl and the transportation. So he ended up with a less severe sentence than he was eligible for. So the state contends that there was no error, nothing unfair about his sentence in this case, that it was proper, it was lawful, it doesn't offend double jeopardy, and that it gives prosecutors tools to get after this very difficult problem of lacing one drug with another.
Let me switch gears on you a little bit. Just popped into my mind. Say Mr. Ashton wows us and carries the day. What's the remedy he gets? Does it go back for resentencing?
The state would contend that that should not be the case, given what I just went
I understand
through.
what the state contends. You gotta jump on board with me on my hypothetical. He won, what's the remedy? If he wins, what's the remedy? Does it go back for resentencing?
It would not need to go back for resentencing because he got a more lenient sentence than what he could have gotten with the Class Cs that he was convicted of.
Well, that's kind of the point of the question. Can he get in a worse position if he goes back? Because they were consolidated. That doesn't mean that they have to stay that way.
He, yes, that's true.
If we somehow were to agree with the defendants and vacate the methamphetamine, he could end up getting boxcarred on 2Cs.
On 2Cs,
Which would be 225 plus another 225. That could be the result if we vacated the methamphetamine conviction and then the judge decides to boxcar him on 2 fentanyl convictions.
That is correct.
I think that's what you're asking.
Yes, sir. The state agrees that is true.
His sentence can't change. He can't get a worse sentence than he got before, but how the sentence is carried out can remain the same, but end up with a different result is the question.
Yes, sir.
Sorry for the sidetrack.
No, that's okay. I think the point from the state's perspective is that the lacing of one drug with another is very, very dangerous. It's very deadly. This analysis in Hall, while that case dealt with any amount would be okay and the amount is what matters here, the court also used the Cameron language and the language in Blockberger. And when you apply that language in both of those cases, the state had to prove a different act, a different fact, right? The fact that some of the evidence is the same, that's not what is determinative.
Say Mr. Thomas had a nice swimming pool in his backyard, an Olympic-sized swimming pool, and he sprinkled a little bit of methamphetamine and a little bit of fentanyl in there. Does he possess 2 swimming pools, one of methamphetamine and one of fentanyl because there's a mixture?
He doesn't
Or does
possess
he just
2
possess
swimming
one swimming
pools,
pool?
but he has violated both provisions of the statute. He has violated, I guess, this trafficking or possession of both of them. And under Hall, he can be sentenced if it's only possession for both of them. And the state contends he should be sentenced for both when it's a trafficking as well. When you look at that issue of we are not just looking at the act or whether the evidence is the same, we are looking at whether or not he's being punished for the same offense. And the state contends he was punished for different offenses. And the General Assembly wrote it this way because that gives police officers and prosecutors the tools they need to get after this very difficult problem. Any other questions that I can answer for the
I mean, couldn't they have tested, to your point, you're saying they want to give them tools, but didn't they have a bunch of other drugs that weren't tested if they really wanted to?
The analysts testified that they had reached the highest limit, the Class C felony on fentanyl. They could not test any more and get a higher level felony on that. And that when they looked at what amount was left untested, they would not have reached above the 200-gram level to get a higher level felony on the methamphetamine. So it was the analyst's testimony that that was the policy of the lab, that they tested to get to the highest level felony. The state contends, of course, the evidence was compelling. The troopers testified that he was throwing the drugs out of the car before they instituted the pit maneuver that finally got him off the road. And the troopers went back and picked up those bags and then found also a bag at his feet, which was the one tested, and the bags outside the car. But that was based on the policy of the lab because they weren't going to get to a higher level felony. The state contends that this conviction and sentence were proper, they were fair, they're consistent with the plain language of the statute, that there is no need to apply a rule of lenity when the statute is unambiguous, and the state contends that it is unambiguous. and that our Supreme Court has recognized that the Controlled Substances Act does have harsh consequences for drug traffickers, that was what was, that is the case under the Act, and that's what the General Assembly meant to be the case under the Act. And that, frankly, he got a lighter sentence than he could have received, as the court has pointed out, by the way that the court boxcarred a Class C and a Class F versus 2 Class Cs. So we strongly request that the court find that there were no error and sustain both the conviction and the sentence.
Any questions? You said the sentence was fair. Fair is a matter of perspective.
Lawful.
The question is whether
Yes,
it was
sir.
legal or not, right?
Lawful.
Okay, thank you.
Thank you.
Mr. Ashton, got some things to think about that you're going to talk to us about, I presume. Got 4 minutes and 39 seconds left.
That should be enough. Lights on already, to remind me. I was trying to put my thought on the actual remedy here, too. I would certainly submit if this court sent it back, it ought to affirm the sentence for one of them, probably the fentanyl, the larger, and the eluding arrest, and reverse the one for the methamphetamine as duplicative.
So you'd want us to reverse the higher level offense, not the lower one.
Yeah, I mean, my client would like that, but I don't know if the law would generally agree to that usually. Usually when they come back, the judge would, if he had a choice, the state would elect the higher and the judge would impose the higher. I don't believe he can go back and boxcar him now on these other things. The sentence is more than adequate. If the methamphetamine would leave, adding the two together, that's 240 months, that's 20 years. So that's a substantial sentence for, especially for this amount of drugs, which I think, as I said, the total was around 75 grams altogether. They analyzed the 35.6. As far as Blockburger, this is not technically a Blockburger issue. I don't think it sort of arises more under the ambiguity, rule of lenity prong, and also as the cases I went through on basically the merger doctrine, overlapping offenses for the same conduct, which we see in the first-degree murder cases, felony murder, the cases I cited in the memorandum of additional authority, firearms by felon, because otherwise the state or the federal government could parse out and make many charges out of one when it's one act, and that's sort of what they're doing here. They could have added, if the cocaine had shown up, 3 out of 1 thing without analyzing several different things. They have the ability to analyze anything they want. I understand the way the chemist did it in this particular case, but the state could have gone back and asked them to see what is that more brownish stuff in the Yeti and what's this, should we get some other charges? But the defendant doesn't have to prove anything. He doesn't have the burden of proof. So
I guess what is your number one top shelf best argument why any mixture, that phrase, doesn't control? I don't read it as being ambiguous. I mean, it seems like that's very controlling in this case. What's your best argument that that's not how we should apply this?
my best argument comes from the Hall case. There's any mixture, but the Hall case, this court specifically said quantity is not an element. Quantity is not an issue. It could be any quantity. Because one of them was a misdemeanor event, I believe. Whereas when quantity and amount becomes an issue, 28 grams or more, it's an element. And when it's an element, it sort of bypasses the Blockburger test I would submit. And then we get into the thing, we've got overlapping convictions. We're basically one bag analyzed. We have no idea how much fentanyl was in it or how much methamphetamine.
So you want us to draw a bright line rule here and say that it's gotta be over certain amounts with these mixtures, over the trafficking amounts independently? You're asking us to make that rule?
I think it would make some sense, at least. I mean, if the bag had come in over 56 grams or something.
I'm not arguing that it would make
It'd
sense.
be more of an argument that
I won't argue with you that it would make sense, but isn't that a job for the General Assembly to do if that's something they want it to be?
I would think with the higher mixture ought to control, and I think the other should be subsumed in it under these certain facts and circumstances. And there are different levels as well as you go through. And I think I'm sort of running out of time.
That's okay. I'm the controller of the clock, so as long as we got questions, we'll let you stand up there. Mr. Ashton, can you and I agree that the difference between possession of methamphetamine and trafficking in methamphetamine is only the weight? That's the
Correct.
only difference, correct?
Right.
Same with fentanyl. The only difference between possession, that the elements the state has to prove, possession, and the elements the state have to prove for trafficking is the weight.
Right.
Is that right? Okay.
Good.
Thank you, sir. I presume you want to tell us what you want us to do with the case. You want us to just dismiss it and
Especially throw the whole thing out, reverse what you can.
now
I
tell
don't
us
want a
what you
higher
want.
sentence. I'm hoping at least the methamphetamine will go away.
Thank you, sir.
Thank
Thank you for a well-argued case. It's an interesting issue for sure. And good arguments on both sides. The case will be taken under advisement, and you'll see an opinion forthcoming.
All rise.
I did with you too. I did. Maybe I'll bump into Ashbrook sometime. We tried to go to the zoo once a year.
You're about to open Asia.
Yeah, we've got a aquarium society which lets us go to the zoo, and then we get Alex, my son, a zoo pass every year so he can go to the aquarium.
Yeah.
You can't make these facts up. He goes to Boston. What do you think about that? There's always another twist. Be back.